very important role in interpreting the laws, acts and rules. As we all know, we have three important wings. One is legislature, the second is judiciary, and third one is executive. The acts which are enacted by the legislature should be implemented by the executive. The legislature which is enacting the laws or acts should be thoroughly implemented without any misrepresentation. What is happening in this process? When the governments are not keen, when the governments are biased, the representation of the act or implementation of the act is not done in a proper way. When that is not being done, again, the court is the ultimate recluse. The court is the ultimate source to go and fight for the rights, or to make the government or the legislature to look into that misrepresentation or violation or non-implementation. So in this process, we have very interesting background. Today, in Telangana movement, we are trying to understand the role of the courts, the role of the court judgments in Telangana movement, in the issue of interpretation, in the aspect of Mulki rules, and how it is being affected the movement inter alia, like many court judgments which came at an appropriate time or inappropriate time, helped or diffused the movement. And many a times court judgments were very favorable of the people of Telangana, and some court judgments really disappointed them. Why it happens? To understand, because when we are talking about the same court of law, whether it is a local court, whether it is a high court or a supreme court, when we discuss about these courts and the verdicts, why it differs from bench to bench, judge to judge? Because the aspect of interpretation, the problem of interpretation or argument. See, when an issue is raised before the court, what will happen? The arguments will be held. The advocates, the appellants or the defendants, what are the main aspects they are trying to touch or appeal before the court is very crucial. If you are not defending or fighting the case with a particular orientation, means taking the important aspect into the center of the argument, you may lose the case. Like that, in many of the issues we have seen, the court cases lifted the movement or encouraged the movement, means it will not directly encourage. Once a court case is coming in favor of the movement, then definitely people are fighting with the state or the government to get it implemented. Like that, we have many cases. In Telangana movement, if we see, we have nearly 7 important judgments. These 7 important judgments were coming at a juncture when the Telangana movement is starting. The period which we are covering is from 1969 to 1972, when we see 7 court judgments and the nitty-gritty of these judgments, its impact on the movement. If we go through the list of the judgments, the first one is Justice Kuppuswamy verdict on Mulki rules in APSCB, January 1969. Then second one is Justice Tslprb verdict on 3rd February 1969. These first 2 verdicts were not in favor of Telangana employees. And third judgment, High Court Division Bench quashes Justice Tslprb's verdict. Then fourth one, Mulki rules are unconstitutional, says the Supreme Court full bench on 28 March 1969. Then again, Mulki rules are constitutional, says High Court full bench on 9 December 1970. Then Mulki rules are void, means not constitutional, says 𝗧𝗧 full bench on one Venkat Reddy appeal. This is happening on 14 February 1972. Then comes the last judgment which has put the full stop for all these cases of 1969 phase, that is Mulki rules are constitutional, says the Supreme Court full bench on 3rd October 1972. So let's look into these things. in detail, and before that we have to understand the background for the judgments on Mulki rules. If we briefly recap the whole issue of Mulki issue, the first phase or the first time we are talking about the Mulki issue in 1880s under Mir Mahbub Ali Khan. First time the Mulki issue has cropped up in terms of the locals and non-locals. The locals are Dakhanis or Hyderabadis, and non-locals are the people who are coming from North India or some other part of the country and occupying the important post. First time the rumblings, first time the resentment or dissent was happening during 1880s under Mir Mahbub Ali Khan. But later many things are coming. We are not going into those things as we have already covered. So, come 1900s. In 1900s, in 1919 to be more specific, Mir Usman Ali Khan's Farman is very important. Mir Usman Ali Khan's Farman, the last Nizam, the 7th Nizam, Mir Usman Ali Khan's Farman of 1919 clearly mentioned the eligibility for a Mulki, that 15 years of residence, and the other aspects like marriage status, how if you are marrying a Mulki, becoming a Mulki, or residence here for 15 years, so that, and giving an undertaking that you will not leave after the retirement also. Like that, the Mulki rules were made very strict to favor the locals. This is 1919 Farman of Mir Usman Ali Khan. So, in independent India after 1947, as we have seen after 1947, in 1948 only, Hyderabad state became part of the Indian Union for all practical purposes, for administrative purposes. In 1949, the Civil Services Regulation was being enacted. This Civil Services Regulation was brought under the military government under J.N. Chowdhury, but it is not much difference. But he was promulgating or he was issuing the same 1990 Mulki Farman of Mir Usman Ali Khan, and this is the first one in the post-independence India or post-Hyderabad state of Nizam. The other aspect is Article 35B of Indian Constitution. Remember this, Article 35B of Indian Constitution gave constitutional validity for the Mulki rules from 26 January 1950. Hyderabad state was included in Article 35B. Why? Because it has a specific historical background when it is being part of India, when it is being taken into India or merged into India. So, in this background, since Indian Union is having different states with different backgrounds, different periods, different historical accounts and different political setup, but Hyderabad is becoming part of it. And Hyderabad is completely different with already existing Mulki rules of 1919. So, safeguarding this Mulki rights of the Mulkis, rights of the locals, this Article 35B is very, very important. So, Article 35B gave the constitutional validity for the Mulki rules through our constitution. Otherwise, what will happen once a state is merging with the other country? You may not get the same aspect as you will have before, because rules are completely changed. It's a different story, different country altogether. So, Constitution has made a provision for this. And next, Hyderabad General Recruitment Rules of 1955. What is this Hyderabad General Recruitment Rules of 1955? It was issued with the signature of Raj Pramukh. Who was the Raj Pramukh? Mir Usman Ali Khan. When the constitution came into force, as we all know, Mir Usman Ali Khan became the Raj Pramukh, who was signing as the Raj Pramukh, and the Chief Minister was Burgula Ramakrishna Rao. And this Hyderabad General Recruitment Rules of 1955 very clearly says, for the appointment of state or subordinate services, these are the rules. 1. No individual who is not an Indian citizen can be appointed. This is coming in a different background because it's a new country and many people from different countries were there and going or coming, and this is the first stage. So, Indian nationality is a must. Even today, if all the rules, if you see for appointment, nationality is a crucial issue. Without if you are not an Indian national, it's not so easy to get appointed in this country. So the first rule is about the citizenship of the country. Second one is must have the 15 years of local residence certified by the designated authority. An authority who is authorized to certify that this person is living for the past 15 years in this state. So this is the second rule. Those 15 years again you can take back to the Mulki rules of Hyderabad state. 15 years of rule, the rule of 15 years is going back to Mulki issue, the of Hyderabad state. So next one is AP Public Employment Recruitment as to Residence Act of 1957. Why? What is the need of this act? In 1956, a new state has emerged, that is the state of Andhra Pradesh. The state of Andhra Pradesh, which came into existence as a result of merger of Telangana area of Hyderabad state with the Andhra state. So now again you have to form the rules or act. That act is known as AP Public Employment Act. So in AP Public Employment Act, which was enacted in 1957, rules were made in 1969. Rules formulated and implemented from 21st March 1959 means actually act was made in 57, but rules are being formed in 59. You can see the difference, the delay in implementing the things. So the eligibility for the appointment and subordinate services and local bodies, except cantonments, because cantonment is also a local body. All the rules, when we speak of the Mulki rules, you see, except cantonment. Why cantonment is excluded? Cantonment is coming under the purview of central government. Though cantonment local body is there, it is not the state government which has to rule or oversee the administration of cantonments. So cantonment is military. So 15 years of residence, and second thing is, this is crucial. When they talked about this 15 years of residence, the second aspect in 1957, this is very, very important, remember. Violation of this has made the life hell for the Telangana employees or Telangana aspirants. Every second post out of 3 vacancies in HOD offices, head of the department offices in Hyderabad and Secunderabad and Secretariat is reserved for Mulkis. Every second post, remember, if there are 3 posts, 1, 2, 3, and the second post is reserved for the Mulki, they are not saying that every 1 post out of 3, they are saying every second post out of 3. Why this is important? This is a small, measure, but it's an important measure. See, if you say every 1 in 3, then you may not get 3 vacancies at a time. You may create 2 vacancies, then what will happen to the vacancy of the second one? So whenever you have to create, if you are stopping by creating 3rd vacancy, then automatically these 2 vacancies are also gone. So automatically what they are doing is every second vacancy, they are giving the second vacancy to a Telangana person, a Mulki, to be filled with. So this every second vacancy, how the violation happened in the next phase? Very interesting thing. When they are notifying for 3 vacancies, this second vacancy also they are notifying. But when they choose the employees or elect the employees or select the employees through interviews or whatever mode, they are saying that this second employee or second post, for the second post, the Mulkis which is reserved for, the people who are coming for the second post are not eligible or fit for the post. So automatically this is not being filled. This is notified but not filled. So 1 and 3 are filled. This is very interesting phenomena, or very interesting story, very interesting violation to deceive the people of Telangana when it is coming into implementation. So this is AP Public Employment Recruitment as to Residence Act of 1957. Then comes, this is applicable for 5 years only. Till 21st March 1964, the rules which were formed in 1959 will be applicable for 5 years. Act 57, Rules 59. Then add 5 years, it comes to 1964. This is applicable for 5 years till 21st March 1964. And because this is not implemented, this non-implementation of the Mulki rules was protested by Telangana Regional Committee or employee organizations, as it should have been done in all the past 5 years. So automatically what is happening? The government was extending this for further 5 years, and the next deadline is till 21st March 1969. So 59 to 69, 10 years of period, this AP Public Employment Act is guaranteeing every second post out of 3 posts for the Mulkis and 15 years of residence. This is the crucial issue or important aspects of this act. So what has happened in this 10 years? Though they formulated rules, it was not implemented. As a result, first extension. So after extending also in 1968, we could see a huge movement for the safeguards. That is why the movement which started in 1968 by Telangana employees is known as Safeguards Movement. Safeguards Movement started by TNGOs under the leadership of Amos, Amos. Violations occurred in spite of this act, and as a result, this Safeguards Movement by TNGOs was happening in 1968. Remember, you may get a question in objective type. What was the major issue for the Safeguards Movement? That is violation of AP Public Employment Act. Then comes very interesting aspects. In 1969, what has happened? The movement broke from Khammam, Palvancha, and spread to the entire country. Country in the sense I am talking in terms of Telangana. Country not in terms of nation or India, the land, Telangana land. In January, there was a verdict, that is Justice Kuppuswamy verdict regarding the employees of APSEB. APSEB, some of the employees were retrenched from AP State Electricity Board, and they approached the court. Why they were retrenched? This is the first story, first important aspect. In 1968, when K.R. Amos and all these people has brought the agitation to the doorsteps of the government, the whole movement was serious about the employment. The whole movement was about the employment safeguards for the employment in the state government jobs. So what has happened? The government came out with a GO saying that all the non-Mulkis should be sent to their native states. That is, native state in the sense it is Andhra Pradesh. Andhra state before 1956. So the employees from Andhra should be sent back to Andhra, and if at all there are no posts, create supernumerary posts and people should be taken there, and the employment or the vacancies which are arising out of sending the non-locals to their native areas should be filled with Telanganites. That is how the rules were formed or the GO was issued. Once the GO was issued, in some of the departments, like the GO was issued on 30th March 1968, and some of the Mulkis, some of the non-Mulkis in Panchayat Raj, Electricity Board, Education were removed or transferred or removed from the posts in Telangana, and they have to be rehabilitated or sent to Andhra once they are removing here. Even that rule says it is unconstitutional. We did not implement the rule, so we have to send. This is the matter which was written in the rule by the government. This is not happening out of greatness, out of magnanimity. It is happening because of the pressure applied by the TNGOs in the government, with the government. So, when these people were retrenched, what is happening? These people approached the court, and Justice Kuppuswamy, Alladi Kuppuswamy, has given a verdict saying that since AP State Electricity Board is an autonomous body, the rules of Public Employment Act is not applicable. If we go through the original act, what is written in the act? subordinate services of state or state government, and 𝗵𝗍𝗃, it's a board and it's autonomous. So what you call interpreting the whole thing like 𝗵𝗍𝗃 is an autonomous body, so the Public Employment Act is not applicable for them. So you have to take back the 𝗵𝗍𝗃 employees who were retrenched. This was the verdict of Justice Kuppuswamy. This is not in favor of Telangana employees. And this verdict is coming on 3rd January itself, before the launch of the 1969 movement in the first week, or from 9th onwards or 8th onwards, you have the intense movement beginning, the rumblings happening in Khammam and all those areas. So this judgment is the first one. And second one is Justice 𝗧𝗦𝗔𝗧's verdict. 𝗧𝗦𝗔𝗧 gave a verdict on 3rd February 1969. And this verdict is coming in the backdrop of GO number 36. GO number 36 came in the month of January. In the month of January, when the agitation started in Khammam, it spread to all the Telangana areas, towns. Hurriedly, the state government under Kasu Brahmanand Reddy called for a meeting of all parties, and the GO number 36 is a result of this all-party meeting. That GO number 36 is talking about the Mulki issue. The first statement, or the GO number 36 and the all-party meeting gave a statement saying that, yes, we do accept that the safeguards or the provisions for Telangana were not implemented. They are accepting it. As they have accepted, again they are issued a GO number 36 favoring Telangana employees. When this GO number 36 was given, again people went to the court. This GO number 36 was contested in the High Court, and Justice 𝗧𝗦𝗔𝗃 was saying that Mulki rules for Telangana region are void. It's unconstitutional. The Section 3 of the Public Employment Act, residence in brackets, rules framed along with this act. Then amendment of 1964. In 1964, one amendment or one extension was given because of non-implementation. When the protest is from TRC, again this act was extended for 5 more years so that it will be beneficial for Telangana employees. So 𝗬𝗏𝗧 verdict says this is also unconstitutional to extend the residence clause. And finally, the GO number 36, which is favoring Telangana Mulki issue, is also void. So Justice 𝗬𝗏𝗧 verdict is a verdict which is against the interests of the Telangana people. So what has happened? The government has appealed before the High Court division bench on this verdict. What will happen whenever you have a verdict with a single judge? You may appeal further. You may appeal the High Court or the higher process, so that if you are not satisfied with the verdict. So similarly, what has happened? The government has appealed before the High Court, and the division bench is going to discuss about this verdict. So till now we can see the first part of the movement. When the movement is beginning, just before the movement itself, you have got a verdict, that is Justice Alladi Kuppuswamy verdict, quashing the rights of the Mulkis, quashing their Mulki rules. Not in all the areas. He says, when you are approaching, that's what in the beginning I said, when you go to the court, when you approach the court, you will be talking about the court with reference to one particular aspect. It was the 𝗵𝗍𝗃 employees, retrenched 𝗵𝗍𝗃 employees. They took the argument that 𝗵𝗍𝗃 is an autonomous body. So automatically the verdict will be focusing on the nature of the 𝗵𝗍𝗃, and finally the verdict comes as if 𝗵𝗍𝗃 is an autonomous body. As a result, what we have seen is 𝗵𝗍𝗃 rules, 𝗵𝗍𝗃 is out of Mulki rules. Then comes Justice 𝗬𝗏𝗧's verdict. It is again based on the GO number 36, which is a result of the agitation. The agitation of at least 9 to 19th, almost for 10 days, the intense agitation. and the what you call pressure generated in the Telangana society on the government is forcing the government to bring the GO number 36, and that GO number 36 is challenged in the court. And now you see GO number 36 is becoming the discussing point, and not just GO number 36, it is not the what you call the aspect how you are issuing a GO, but they are discussing, means Justice चिन्नप्प Reddy is discussing the section 3 of the Public Employment Act, that is residence aspect, and the rules, and finally the extension in 1964, and even the GO itself. So all things are becoming unconstitutional. This is Justice चिन्नप्प Reddy verdict. So to sum up the first part of the court judgments, what we want to say is, this first part is very, very clear, and it is about the beginnings of the interpretation of court judgments in Mulki issue. And Telangana is always a Mulki. In Telangana, the agitation or the state demand is based, or it is always revolving around the Mulki issue. As we have seen, if we say the first verdict is Kuppuswamy's verdict, Justice Kuppuswamy's verdict, the last verdict is, if you see, that is 14F, which has completely changed the course of agitation, the course of the movement, which entered into the phase. And finally this 14F and local Hyderabad free zone, all these things are related to the court, related to the verdicts of the court. And these are the issues which stirred the issue of Telangana state, as we see. So in the next part of our court judgments, we will be looking in the other court judgments. In the second part of the lesson, that is court judgments, we will be seeing what is happening from the month of March, because March 1969, because what is happening after Justice चिन्नप्प Reddy's verdict, now there is a question mark put on the GO number 36. GO number 36, which is very crucial, the first product of 1969 movement. GO number 36 was made by the government to satisfy the Telangana agitation, to support Mulki issue, to give employment. And now with Justice चिन्नप्प Reddy's verdict, the whole GO number 36 is becoming a questionable thing. Along with GO number 36, Mulki rules are also becoming questioning, even the extension. So what is happening? Again, we have come back to square one. So in this background, what will happen? Once the judgment is in favor of non-Mulkis, then some people are going to Supreme Court to get the stay on the transfers which was already ordered. The state government was ordering or issued orders to transfer non-Mulkis to their native places, replacing them from Telangana region. So when they are being asked to leave Telangana or getting transferred or removing, so automatically when the GO number 36 is questioned, though they are going to the court and getting the stay on this GO number 36. So GO number 36 was questioned on 17 February 1969. Supreme Court stayed the implementation of GO number 36. Supreme Court stayed, and this case was filed by AVS Narasimha Rao, that is an appellant, and 7 others. They went to the court against the government of AP. As we have seen, Justice चिन्नप्प Reddy's verdict came on 3rd February, and this is 17th February. So AP government stayed the process of transfers based on the Supreme Court stay. AP government under Kasu Brahmanand Reddy need a pretext to halt all the things which they are promulgating, which they are starting to satisfy Telangana agitation. So automatically the Supreme Court said stay on the transfers. So they have stayed. On 19th February they have issued an order to stay the transfers, as Supreme Court said. Now next, again interesting, this is like ups and downs in Telangana movement. Court judgments are very, very interesting. And the next judgment, the first two judgments as we have seen are not in favor of Telangana people, not in favor of Mulki rules. But the next judgment, that is High Court's division bench, is quashing Justice 𝗬𝗪𝗺's verdict. High Court division bench, once the verdict of 𝗬𝗪𝗺 came, then again appealed into the High Court division bench, so that we will be discussing is it valid or not, because it is a single judge bench. Now it is division bench of two people, Justice Pingali Jaganmohan Reddy and second one is Justice Justice P. Jaganmohan Reddy, that is Pingali Jaganmohan Reddy, and the second one is Justice 𝗬𝗶 𝗫𝗏. So Jaganmohan Reddy 𝗬𝗶 𝗫𝗏 bench, this bench has said that 𝗬𝗪𝗺 verdict is not correct. So they have quashed, means they struck off 𝗬𝗪𝗺's verdict on 30th April 1969. The 134-page verdict, their verdict was 134 page, and this 134-page verdict has clearly said that the Act of 1957, that is rules of 1959 and the Act of 1964 which was extended, all are constitutional. This constitutional validity given to the Mulki rules is again putting some life in the Mulki issue. Because when you question the original concept of Mulki itself in the 𝗬𝗪𝗺 verdict, as we have seen, Kuppuswamy verdict is concerned with APSEB, but 𝗬𝗪𝗺 verdict is all encompassing. They are talking about the Act, talking about the rules, talking about the GO. Now division bench crashes 𝗬𝗪𝗺 verdict and favors Mulki issue. So this Mulki issue has again come to up, means Mulkis are favorable, Mulkis are favored. This was very important. And again, when the verdict of this division bench came, AP government has approached the Supreme Court for the vacation of the stay. As we have seen, the Supreme Court has issued a stay order on implementation of GO number 36. Then automatically the process is you have to approach the Supreme Court to remove the stay order on GO number 36, because the division bench said it is constitutional. So you can transfer the non-Mulkis. So when the AP government approached the Supreme Court, again a new thing has come up in Mulki issue. That is, the Supreme Court full bench said Mulki rules are unconstitutional. Very interesting again. Now it is individual court judgments, then comes High Court division bench, means two people. Then comes Supreme Court. In Supreme Court, it is the full bench. Supreme Court is supreme than High Court. Now the Supreme Court's judgment is very, very important and it is supporting non-Mulkis. On 28 March 1969, full bench of Supreme Court chaired or headed by Justice M. Hidayatullah and members J.C. Shah, V. Ramaswamy, G.K. Mittal and A.K. Grover, A.N. Grover. All these people, the five-member bench, that is Supreme Court full bench, said Mulki rules to be part of the state is not constitutional. Means they are saying that once you have a state in formation, all the rules should be equal to the state. You cannot have a different set of rules or some safeguards or some special encouragement to one particular region in a state. That is what the Supreme Court full bench is saying. So they have quashed the Mulki Act. Once they have quashed the Act, the rules will also go. Once the Act is gone, rules is nothing but the implementation of the Act. Remember about this legality. Once the Act is formed, immediately again the government and the law department has to form the rules to implement it. Nitty-gritty of the Act means how to implement, who is the appellant authority, who is the authority, where to do, what is the jurisdiction, what are the legal terms. All these things should be interpreted in the rules so that there will be no ambiguity, no confusion, no misrepresentation. So Act and rules go together. This judgment of Supreme Court full bench quashed Mulki Act and rules and finally GO number 36-2. So what has happened? Again we came back to the first phase where we are not finding any solace with the court. Telangana Mulkis are not finding solace. In between, another thing is happening, that is Onechu committee. So when we are talking about this Supreme Court full bench verdict, that is 𝗳𝗍𝗪𝗓's verdict, Justice 𝗳𝗍𝗪𝗓 headed committee's bench verdict, which was declared on 28th March 1969. In the month of July, we have, in the month of April, we have 8-point formula. 8-point formula is very important. That is declared by Indira Gandhi. Indira Gandhi is declaring 8-point formula at a time where the whole Telangana movement was at its peak. Lot of activities are going on and 8-point formula was declared to satisfy this agitation. Remember, Indira Gandhi as always no for Telangana. She was never supportive for the Telangana issue. Why? Because she doesn't want any internal disturbance, as already there was a political disturbance inside the party, inside the government. This is a crucial juncture the Indian state was going, Indian government was going in. Inside the Congress party also, Indira Gandhi was facing opposition. And 70s is crucial period. You have many things are happening internationally. 71, you have Indo-Bangla war. We are getting closer to Russia. In this background, Indira Gandhi is preoccupied with international and Indian events or national political events. And she never wanted to, what you call, in Telugu we call it as 𝗬𝗏 𝗬𝗏, means you shouldn't disturb the honeycomb. Once you disturb the honeycomb, it will sting. Formation of a state is a honeycomb. This was the understanding. And she was adamant. And you can't fight and take from Indira Gandhi. She is such an iron lady and she was not ready to accept or heed to the demands of any agitation. So finally what has happened? Because Indira Gandhi was adamant in that sense not to grant Telangana a separate state, she will come up with different set of formulas. We will talk about this when we are discussing about 8-point or 5-point or 6-point of Indira Gandhi. The psychology of Indira Gandhi when she is bringing these formulas. So, as part of the 8-point formula, a committee was formed which is known as Onechu committee, which is discussing about the Mulki issue. Onechu committee is the expert legal committee chaired by Justice 𝗖𝗍𝗪𝗓 to look into Mulki issue. So, the 8-point formula says we will look into the constitutional legal aspects of Mulki issue and a committee of experts will look into. So, Onechu committee came. This Onechu committee gave its report in August 1969 and it is again what you call not in favorable of Telangana. It is also depressing for Telangana. What it said was Mulki rules, clause 3 of Article 17, for implementation of the Mulki rules, clause 3 of Article 17 has to be amended. Then, if you have to amend, what are the hurdles? Already there was a judgment known as Golaknath case. And in Golaknath case, the Supreme Court said it is not possible to amend in such a way. So, Golaknath case has taken as the precedent and Onechu committee said, if we want to make some provisions, legal provisions to amend the law, amend the Article 17, that is clause 3, then Golaknath's case will not allow it. The verdict in the Golaknath case will not allow it. So automatically what happened? Onechu committee has said that to provide employment for Telangana people, you cannot have a constitutional thing or a thing which is central. So they have provided some measures like make the subordinate employment completely local. Local means it is not state level. You make the employment of subordinate level in the district or exact local level. There you need not go for constitutional amendment. You can have your own say when you are doing it at a local level. Either TRC, Telangana Regional Committee can look after into the employment at the local level. So he suggested that go for local level and you cannot have a constitutional provision for Mulki because Golaknath case was the major thing which is a hurdle. He cites it. Remember in your examination, you may get which case is related to which among the following cases is related to the Mulki rules or Mulki judgments during this period. That is Golaknath case. So the bench came with a verdict that Mulki rules are unconstitutional. Then Onechu committee says Mulki rules cannot be made as a constitutional thing. You cannot bring the credibility or you cannot make the Mulki rules constitutional because of this. Then comes the another verdict, that is High Court full bench said Mulki rule constitutional. Mulki rules are constitutional. High Court bench of 3 members, that is headed by Chief Justice Kumarayya and Justice 𝗂𝗽𝗱𝗁𝗺. The third one is Justice 𝗂𝗽𝗱𝗁𝗺, pronounced a judgment on 9th December 1970. 9th December 1970 and said that Mulki rules are constitutional as per Article 35B of Indian Constitution. That is what I said in the beginning. Understanding a verdict needs what was the thing the judge or the bench or the appellant or the advocate is interpreting. Now they have interpreted Article 35B of Indian Constitution and said Mulki rules are constitutional. And this is High Court bench. Do you think High Court is it is superior than Supreme Court? Supreme Court full bench said it is unconstitutional. Now High Court full bench says it is constitutional. In this case, it is not overriding the powers of Supreme Court, but they have merely taken the question of Article 35B. And they said Section 3 is gone because of the Supreme Court verdict. When you remove Section 3, automatically Section 2 will also go. So what will happen? Mulki rules of pre-57 will be continuing. This Section 3 or Section 2 interpretation is being done with reference to the Act of 1957, AP Employment Act. So once the Section 2 or 3 are gone, now what is happening? The Mulki rules of pre-1957 should be continued and Mulki rules are constitutional. This is the major aspect they were talking about. So again, now to sum up about this verdict, full bench is in support of Mulki rules. Then comes the last verdict, that is last but one verdict, that is High Court full bench. The other one is High Court full bench is saying Mulki rules are constitutional. Then another High Court full bench is saying that Mulki rules are unconstitutional, because it is not the discussion on the Mulki rules. It is the discussion of the appellant's aspects or some points of reference the court will be commenting upon. So once the High Court full bench said Mulki rules are constitutional, another High Court full bench says Mulki rules are unconstitutional. The case is related to Venkat Reddy versus AP government. This Venkat Reddy was an employee in the state government, in the industries department. He and some other people were recruited and they were given training as extension officers, but because of the Mulki rules at the GO number 36, all the happenings of this time, some people were retrenched, some people were demoted to a lesser post. So we, Venkat Reddy and some other people are going to the court. In this case, in this appeal, Justice Obul Reddy, Kondayya, Konda Madhav Reddy, ADV Reddy, Sri Ramulu, all these are justices. All these justices means 5 justice bench, that is High Court full bench, is saying that this Mulki rules are void, unconstitutional. But it is not an unanimous judgment. It was the majority verdict. Majority verdict means 4:1. 4 people said Mulki rules are not constitutional. One person, one justice differed with the 4 and gave a minority verdict, because minority verdict is not to be implemented, but the verdict will be recorded. So minority verdict by justice, who we can guess, among Justice 𝗬𝗏 𝗂𝗽𝗃 𝗂𝗏 శ్రీరాములు, it is Justice 𝗂𝗏 who was giving the other opinion other than the 4 justices. So these 4 people were giving one judgment, and the other one, Justice 𝗂𝗏 said Mulki rules are constitutional. But as the verdict goes with the majority, now Mulki rules became unconstitutional again in the High Court. Then the then Chief Minister P.V. Narasimha Rao, he knows the gravity of the moment. P.V. Narasimha Rao, as critics have difference of opinion about his role in globalization or something, or P.V. Narasimha Rao's political acumen is so sharp, but administration, there are some people who said he couldn't control Andhra Pradesh. But it was a crucial juncture when the agitation was so intense, and when the things are going out of the hands, Andhra leadership or Andhra movements are coming up against P.V. Narasimha Rao, accusing him of bias. So P.V. Narasimha Rao government appealed to Supreme Court after this High Court full bench said Mulki rules are unconstitutional. And the last verdict, which is very, very prominent and important, which has put a full stop for all the arguments in this period in the courts of law, that is the verdict of Supreme Court full bench, which says Mulki rules are constitutional. Mulki rules are constitutional. So the final verdict of this phase is very, very clear. It says Mulki rules are constitutional. On 3rd October 1972, Chief Justice S.M. Sikri, Justice A.N. Ray, Justice Y.D. Duva, Justice D.G. Palekar, and H.M. Beg. All these 1, 2, 3, 4, 5. These 5 people, that is Sikri, Ray, Duva, Palekar, and Beg. This bench, this full bench, declared that Mulki rules are constitutional and said the clause, the number of years designated as in the Hyderabad state, that is 15 years of residence introduced by Nizam rule or Nizam government, is still valid. The validity, the constitutional validity of Nizam's rule of 15 years of permanence was upheld, was accepted, was made constitutionally valid by the Supreme Court full bench. This says Article 371 was amended for the benefit of Telangana. When you amended the Article 371 for Telangana, so automatically you have to provide things, and Mulki rules is one such provision. So the essence of Supreme Court full bench I am talking about. This bench agreed with the High Court full bench verdict, which said Mulki Act is constitutional. We have seen that High Court full bench, Kumaraya's bench, which said it's constitutional. It agreed with that and said they have quoted in their verdict some of the points points written by Justice 𝗂𝗏 favoring Mulki rules. So this bench has mentioned that the political and constitutional background for the continuation of Mulki Act should be understood whenever we want to talk about this one. So constitutional validity of Mulki rules can be studied, can be understood only if we understand the political and historical background of the merger. So Mulki rules should be implemented. This is the verdict, and as a result, P.V. Narasimha Rao, the then Chief Minister, was very happy. He welcomed the judgment. He welcomed the judgment as if as it is going to resolve many issues, because once the court gives a verdict, automatically it will have its impact on the society. The validity is counted. So this is the full bench verdict under Justice Sikri. So remember the names of the judges or benches and headed by. These are the questions you can expect in your examination. So what are the things happening in this entire period? If you want to understand, if you want to sum up, if you want to come to some generalization, the first aspect, as I said in the beginning of court judgments itself, is the points of reference in any court or in any appeal is very, very important. Point of reference means what? What are you arguing for? Are you arguing for a small issue, or you are arguing about the generality of the act? Sometimes the court judgments are pronounced, though it is taking the minute aspect, one specific aspect, it comments upon the broader aspect of the act. Like when you talk about 𝗵𝗍𝗺, the first judgment is related to 𝗵𝗍𝗺 only. They are not giving much of the wider scope. He is not, the Justice Alladi Kuppuswamy is not giving a wider scope to his judgment. But when it comes to 𝗹𝗶𝗻𝗺's judgment, Justice 𝗧𝗦𝗔𝗧 judgment, it is very, very clear that Justice 𝗧𝗦𝗔𝗧 judgment is coming to a phase where you are commenting upon not just a simple issue of GO number 36, you are talking about the broadest aspects of it. So to conclude, since January 1969 till the last verdict of Supreme Court in 1972, majority of the court judgments were not in favor of Telangana. Whether it is local single bench, single judge bench, or Supreme Court full bench. It impacted upon the Telangana movement. Sometimes we got what you call disgruntled, sometimes we get depressed, and sometimes we got a boost. So some of the verdicts did not take the historical background of the Mulki rules. As a result, they are looking at mechanically about the constitution or the country as a unit or a state as a unit, and saying that you can't have a set of rules for the state, for a region in a state. It is discrimination, they are saying. But they are not taking into the account that historical and constitutional background when you are making an act. So the last point about the summing up is, the judgments which are not in favor of Telangana were definitely acting as a detonating thing or a stimulant to go for protesting or go on protest to continue the agitation and demand a separate Telangana state. Because in the United Andhra Pradesh, if the rules are not in favor of Mulkis, that is Telanganites, so staying in Telangana, staying in United Andhra Pradesh is not possible, because we may not get jobs. This strong understanding in Telanganites is very important, and as a result, whenever you have a judgment against Mulki rules, it will become a precursor for the movement, or a stimulant, or a detonating thing for the movement. See, it is the employment which is ultimately we need. If you see, whenever there is a favorable thing for Telangana, the movement could be happy and could fight for the right. But when the last judgment was pronounced by the Supreme Court saying that these Mulki rules are constitutional, Andhra people went into agitation. Jai Andhra movement came. Jai Andhra movement is a result of the court judgment. Court said Andhras are non-locals in Telangana, so they can't take an employment, take a job in Telangana. Then they asked for separate Andhra state. Till then Telangana was asking. You can see a very clear difference. Unless, if you have the employment, you will not fight for the statehood. At least this is one of the reasons. And Telanganites were asking for employment, they did not provide. The United Andhra Pradesh did not provide, so they went on agitation in 1969. But in 1973, when High Court said, Supreme Court said, Andhras are non-locals and they may not be favored in employment in Telangana region, immediately Jai Andhra movement came and they said they want a separate Andhra state. You can see the logic behind it. So To sum up the court cases or judgments, what we say is court judgments is an important chapter which interprets the aspect of Mulki in Telangana issue.
నార్మలైజేషన్ ప్రక్రియ ఎందుకు చేయాల్సి వస్తుందంటే ఏఆర్ పోస్టులు ముఖ్యంగా ఏఆర్లో ఏం జరుగుతుందంటే 10% రిజర్వేషన్